nothing I can do about it. I can just apologize to the court. That's all.
Because just absolutely shame on you for putting your daughter through this as your grandchild at home. What, 4 months old, 5 months old?
Please bring me 51 grams of methamphetamine in a Flamin Hot Cheetos bag and wrapped in a condom.
Right, they heard phone calls talking about chips. They found the chip bag in the trash. That's enough for them. Case closed.
In Warren County, Ohio, Kenneth Carney was already serving time inside Warren Correctional Institution when investigators say he found a way to keep working from behind bars. On July 28, 2024, 51 grams of methamphetamine were discovered inside the women's restroom near the prison's front entry, hidden inside a Flamin Hot Cheetos bag. Carney never touched the drugs and never left his cell, but prosecutors argued he didn't have to, claiming he directed the operation from inside the prison and that his own daughter carried the drugs in for him, a young woman with no criminal history and a 4-month-old child at home. With the evidence presented and testimony complete, both sides prepared to deliver their closing arguments to the jury before Judge Timothy Tepe took the bench for sentencing.
All right, ladies and gentlemen, at this time we've concluded the presentation of the evidence. We're going to move into the closing arguments of counsel. Ms. Nicholson, you go first.
Thank you, Your Honor. Ladies and gentlemen, now that you've heard all the evidence in this case, I want to explain how the evidence that you've heard satisfies each and every element the state is required to prove to you beyond a reasonable doubt. The defendant has 2 charges in this case. Count 1 is aggravated trafficking in drugs. That on or about July 28, 2024 in Warren County, Ohio, the defendant knowingly prepared for shipment, shipped, transported, delivered, prepared for distribution, or distributed methamphetamine when the defendant intended to sell or resell. There's also going to be an additional finding. If you find the defendant guilty of this, you're going to ask if the weight of the methamphetamine equals or exceeds 5 times bulk but is less than 50 times the bulk amount of methamphetamine. Chamberlain, you heard from Sergeant Klontz. Drugs are valuable in prison. They have a high value, whether that be a monetary value, whether they're splitting it up and shipping it off to different people. But you also heard that 51 grams of methamphetamine is not a common amount to find. Because if somebody brings in 51 grams of meth, that's probably harder to conceal, right? And that's a lot to get caught with. And so they split it up quickly. They get it out, they divvy it up, they get rid of it. Well, you heard from Mr. Carney himself. Nothing's free in prison, right? Everything costs something. Commissary, hygiene. Everything you do in prison costs something. Meth costs something. 51 grams of meth, the only purpose of that in a prison is to give it to other people. That wouldn't be very smart, would it? You heard Sergeant Klontz testify. Those calls are recorded. They know that. It's on that little intro. Those calls are monitored. Those are some key words there that they don't want to use. So it's of no surprise to anybody that we don't have a call that says, "Bring me in drugs," because that would be dumb on Mr. Carney's part. So he uses coded language. That's typical in these cases. He speaks in code. Bring the flaming, bring the glass house. Mr. Carney wants you to believe that that is something completely unrelated. And I think he gave about 4 or 5 different explanations of what those words meant. He speaks in code. Bring the flaming, bring the glass house. Ladies and gentlemen, the state has met its burden, proven all of these elements to you beyond a reasonable doubt, and we would ask that you return a verdict of guilty. Thank you.
Thank you, Ms. Nicholson. Mr. Brenner.
Thank you, Ryan. Ladies and gentlemen, thank you for sitting through the last day and a half of trial here. I think in general, it's, there's a reason why a solid half of the Bill of Rights pertain to the rights of the accused, right, in criminal proceedings. And that is because the Founding Fathers, and we up to this day, consider the rights of individuals to be extremely powerful and valuable. Right? It is the burden of the state. I've been talking about this since the first time we spoke. It's the burden of the state to prove beyond a reasonable doubt the allegations in each and every case. And so I'm asking all of you, you're going to have the evidence with you, right? You're going to have the calls. You're going to have the video. Pay attention to everything. right? Because at the end of the day, I think it's notable, Ms. Nicholson just pointed out, hey, it would be preposterously foolish, right, to mention drugs directly on a call, because that's going to get your calls flagged, right? So therefore, right, Mr. Carney must be speaking in code. However, he's explicitly talking about Cheetos bags over and over and over. So on the one hand, right, he's such a clever operator that he would never deign to mention drugs, right? But on the other, he's talking about the chips. And so, I just want to point that out. I think it's indicative of kind of some of the assumptions, and the conjecture that has gone into the state's kind of investigation and their conclusion on this case, right? There are ways to prove all of this, right, pretty conclusively. Where was Mr. Farley's testimony, right? We never heard from White Mike. We never heard from Adrian Johnson, right? We don't have body cams of, setting up this alleged decoy. We don't even know, what was in the decoy, right? They heard phone calls talking about chips. They found the chip bag in the trash. That's enough for them. Case closed. See you later. Right? But at the end of the day, ultimately, right, it is their job to prove that Kenneth Carney was involved, right, with bringing in this item to the trash can. Right? I put it to you that if this was the plan, this was the goal, right, that Adrian Johnson, Kenneth Carney, Kalia Carney have cooked up this idea of, hey, we're going to bring in these drugs and drop it in this trash can. So Israel Farley, who again has no ties to any of them, there's never no testimony that he knows any of them, can pick it up. Right? Why in the world would she schedule a visit for herself? The state wants you to have it both ways, right? They want to say, okay, right, the answer is he worked with Farley. That's how we got the stuff, right? But on the other hand, we know from the calls, and you're going to hear those calls, right, that Kalia intended to visit her father that day. She was taken to the wrong jail, wrong prison. Lebanon and Warren are right next to each other down the street here. She was taken to the wrong one. She had to walk in the rain. Right? She said herself during her testimony, she had to clean herself up. She went into the bathroom. She wiped herself off with paper towels. There were paper towels in the trash can. Right? But what we don't have, and we don't have any idea of who else was in the bathroom that weekend. We do know that that bathroom was last cleaned on Friday and then went back in on Sunday. Right? We have testimony that that bathroom is open to the general public. We have testimony that there are incidences where COs or staff bring in contraband. And again, the state here is going to ask you all to overlook, I would say the laziness or the inadequacy of their investigation, right? Again, where's Farley? Where's Johnson? Where's White Mike? Where are Farley's calls? Where's the surveillance footage, right? Where's the body cam? And again, I think we heard from the investigator, we heard from Trooper Klontz. They didn't need it, right? They had a suspect. They're good. We're done. Close the investigation, right? The problem is, the person that needs to be sitting in this chair right here is Israel Farley, and he's nowhere to be found. We do not have any evidence about Mr. Carney's mental state or his intention of what he's going to do with this, contraband. There's calls, we heard testimony, there's dozens and dozens of calls. Mr. Carney testified himself, he's on the phone all the time, right? There's nothing about selling money, right? There's nothing about drugs or the bathroom or a trash can, right? There's plenty about food, tons of food, right? Cheeseburgers, chips, Gatorade. He explicitly mentions chips and Gatorade in any calls that you're going to hear, right? He testified about how important food is, and that's one of the big draws of those visits, right? You could tell by the expression on his face. He enjoys those visits. He loves those visits. So, ladies and gentlemen, jury, thank you. Again, pay attention to the evidence and render your appropriate verdict.
Thank you, Mr. Brenner. Ms. Nicholson?
Thank you. Can you flip me over? He asks for everybody to bring him a bag of Flamin Hot. And he asks, put the glass house in it. Adrian Johnson says she's got a bag of Flamin Hot and an egg roll. Investigator Chamberlain testified it could have been the trash can, it could have been the pack itself that Glass House was referring to. Mr. Carney wants you to believe it's something dropped in the bushes for somebody named Aaron. Ladies and gentlemen, you are allowed to and encouraged to use your common sense in this case. And I ask you to do so. Two things can be true. Kalia could be there for a visit with her dad, and Kalia could be there to drop drugs on her way in. Both of those can be true. They are not mutually exclusive. Now I want to talk to you about credibility. The jury instructions are going to tell you that when you weigh Kalia's testimony, she's an accomplice, right? She's a co-defendant. You are to weigh her testimony with caution. And you all express that in voir dire. If the getaway driver testifies, you're going to be a little suspect of their testimony, right? But the jury instructions are also going to tell you that the testimony of the defendant is also to be weighed as everybody else's. So, arguably, they both have some self-serving motives, right? Kalia said she was hoping to help herself by testifying. So's the defendant. And he wants you to believe that Kalia got up there and just 100% lied. Ladies and gentlemen, does that make any sense? You all witnessed her testimony yesterday. She looked like somebody who just completely made up that story. She hated being here. She's here because he made her be here. He put her in this position. And she got up there and she told you the truth. Because her testimony is consistent with the phone calls, her testimony is consistent with the surveillance video, and her testimony is consistent with the messages she has with her dad. Do you know what Mr. Carney's testimony is consistent with? Absolutely nothing. It does not match any of the other evidence in this case. The defendant would have you believe he's talking about literal snacks on these phone calls. Bring me chips, bring me Gatorade. I just love Flamin Hot chips. They're my favorite. So I guess it's just a coincidence that somebody used that exact same time frame as we're talking about to drop off 51 grams of meth in a condom that looks suspiciously like an egg roll, in a Flamin Hot chips bag, in the bathroom at Warren Correctional, at the same exact time his daughter's there. That's just, I guess, a mighty coincidence. A coincidence that an inmate he's had no involvement with, no connection with, Israel Farley, named Philly. Ladies and gentlemen, just because an explanation is the simplest one, doesn't mean it's wrong. The defendant would have you believe that he's talking in these calls about, I couldn't even keep track, THC edibles, sex toys, sex edibles. He's a bag collector. It's special designer bag from a dispensary that he wants Adrian to keep for him. There's a gift for Aaron in the bushes that was dropped off hours before or on the way to the visit or something. That is also what Kalia, while she's in the process of missing her visit, is confirming that she left or somebody else left somewhere for Aaron. Ladies and gentlemen, ask yourselves if any of that made it. The state has met its burden. Use your common sense. Look at what evidence matches, what evidence is consistent with the testimony that you heard in this case. Based on all of that, the state is going to ask that you find that everything on July 28th, 2024 at Warren Correctional Institution began and ended with Kenneth Carney. And we're going to ask that you find him guilty. Thank you.
Thank you. Mr. Carney, is there anything you'd like to say before I sentence you?
I just apologize. There's nothing I can say, but apologize to the court. I have nothing to do with it. I still remain innocent, but you know,
I'm sorry, I can't hear you.
I still remain, you know, innocent to where I didn't do it, but there's nothing I can do about it. I can just apologize to the court. That's all.
You know, the court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. There are two offenses here. The court does find that they are offenses of dissimilar import and do not merge for the purposes of sentencing. Anything on that?
No, the state would agree.
Your Honor, I would ask for them to merge, but I do believe that under Ohio law that they would not automatically merge.
All right, on count one, then, the court will order you to serve a minimum term before I get to that, Mr. Carney, first off, shame on you. Just absolutely shame on you for dragging your young daughter, who you profess to love, into this, as the defendant, in front of a jury. And I'm doing it for a reason. Because just absolutely shame on you for putting your daughter through this and having her face an indictment with mandatory prison. Luckily for you, I think that the state, and I think we're going to do it on Thursday, her trial was set for Thursday, as you probably know. If she gets convicted, I didn't have a choice but to send her to prison. She has no prior record. Why would you drag your daughter into that, who has your grandchild at home? What, 4 months old, 5 months old? Why would you do that? And that's a rhetorical question, Mr. Carney, because quite frankly, I'm not looking for a response at this, but I'm just scolding you because I think it's shameful for a parent to drag, and we see these cases all the time where people, they talk these young women, but to talk your own daughter into doing something like this is just absolutely disgraceful, in my opinion. Your record dates back to 2001, your criminal record. So you have a criminal history of over 25 years. This is your third conviction for aggravated trafficking. 3. You're not learning anything. So the court is going to order you to serve a minimum prison sentence of 5 years, a maximum prison sentence of 7.5 years. That has to do with Reagan Tokes, as you probably are aware. And on count 2, the court's going to order you to serve 36 months, that to be served concurrent with count 1, but consecutive sentence to your current sentence. So I'm adding on 5 to 7.5 years to your current sentence. The court does find that a consecutive sentence is necessary to punish you and to protect the public from you. It is not disproportionate to the conduct or the danger that you pose to society, and this offense was committed while you were already incarcerated in the Department of Corrections. You have 0 days jail time credit. You are subject to a mandatory period of post-release control on this, as you probably already are on your other one, which means that when you are released, the Adult Parole Authority will supervise you for up to 3 years, but not less than 18 months. If you violate that supervision, you can be returned to prison by the Adult Parole Authority for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time will run consecutive to any additional prison time that you receive. You have 0 days jail time credit on this 5 to 7.5. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Because this is a mandatory prison sentence, you are not eligible for early release. You're not eligible for the good time credit of 5 to 15% against your Reagan Tokes time. Regardless of that, the Department of Corrections, when you finish your minimum term of 5 years, the Department of Corrections, unless they determine that you will be released when you complete your minimum term, unless the Department of Corrections determines that you must remain in prison for bad conduct. The court is not involved in that decision. Has the Department of Corrections added any Reagan Tokes time onto your current sentence? Not yet?
No.
All right. If you're not released when your minimum term ends, you will serve an additional specified period of time, and given a new release date, you will serve until that date unless you are again denied release, and that process could repeat until you are released. You do have a right to appeal the jury's verdict and this court's sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Stickles?
Nothing further, thank you, Your Honor.
Mr. Brunner?
Not at this time.
All right, that's all, thank you.
The jury returned guilty verdicts on both counts. The primary charge, aggravated trafficking in methamphetamine at 5 to 50 times the bulk amount, carries a mandatory prison sentence under Ohio law. Under the Reagan-Tokes Act, that sentence is imposed as a minimum and maximum range, with a parole board determining the actual time served. Judge Tepe sentenced Carney to a minimum of 5 years and a maximum of 7.5 years on count 1 to be served consecutive to the sentence he was already serving, not alongside it, but after it. This marked his third conviction for aggravated trafficking, with a criminal record dating back to 2001. 3 days later, his daughter was set to stand trial on related charges tied to the same events, allegations that she brought the drugs into the facility at his direction. A conviction on her end carried mandatory prison time with no discretion for the judge. That is the consequence Carney set in motion when he picked up that phone and started talking about Flamin Hot Chips. 12 jurors found Carney guilty on both counts. If you think you would have reached the same verdict based on what you just watched, drop your verdict in the comments, and if cases like this are what you come here for, make sure you are subscribed.